I think it's too long. I think everything can be done in 30 minutes. Yes. I'll do so.
Period of time so that we can convene and proceed.
Yes, I thought 30 minutes should suffice. Yeah, they say. They indicate 30 minutes is fine.
Yes, in that case, thank you, Mr. Gelasso. I will stand this matter down to 10 o'clock. Then we will resume continuing before G. Is your client on any bail or not?
They are, most of the accused are out on bail.
I'm asking.
The accused number one.
Thank you. Who is appearing for accused number 2? Please, please, please repeat your name.
My lord, sorry. My colleague is not. What she says will not be recorded.
Did you say your surname was Mahalo?
It's Mohammed, my lord.
Mahano.
Yes,
And your initials?
it's M.
FM.
M.
Is
Assisted by counsel M. Shlanga.
Mslanga.
Yes, my lord.
Accused number 2 is also on bail.
I believe so, my lord.
And accused number 2 is present in court.
Yes, sir.
Thank you.
And that accused number 2 is not ready to proceed, my lord.
He is not ready to proceed.
No, we're not ready to proceed.
Why not?
My lord, the accused applied for assistance from legal aid, and his application was declined, and therefore it's only on the 6th of April that my office came into record, and we were only able to brief counsel, and he was able to appear on the 11th.
But you say Advocate Mslanga is not ready to proceed.
She's not available. Yes. did not have time to seek any alternative advocate. He was the advocate.
I'm assisted, my lord, by Advocate Tenille Governor.
I'm sorry to interrupt you, sir. Your initials and surname?
LM, and my surname is Hodes, Hodes. And my senior, and my junior is Miss Governor. Her initial was T Governor. And we're instructed on behalf of accused 3, 4, and 13, my lord.
Yes, I have it,
Our
thank
attorney
you.
of record is Victor Kwashu of the firm DNA Incorporated. He's unfortunately absent as a bereavement. His mother passed away on Sunday. He's been at every other pre-trial and appearance relating to this matter.
Thank you, Mr. Hodes.
May I state our position on record?
Yes, please.
My lord, and it was on the national media that predicted that this matter would not run. We are ready on behalf of all 3 accused, but we were informed by my learned friend for the state that the matter will not be running. I have a full account of everything. If I may just take your lordship through a brief summation.
Yes.
Because it appears that your lordship isn't a favourite with the enormity of this matter, and The attorney who appeared for accused number 2 referred to 126 pages, which shows...
Mr. Houders, I'm fully aware of the enormity of this
It's
matter.
126,000 pages, my lord.
Yes,
26,000 pages, my lord.
yes, and there are more than 90 state witnesses that will testify, and there are almost 100 charges, and there are thousands of documents that will be handed in. That at least I'm aware of.
Perhaps I can be of assistance to this honourable court. Accused 1, 2, 3, 7, 9, 11 and 12 were arrested on J50 warrants, my lord, as far back as the 30th of September 2020. Bail was set, they were in custody overnight, bail was then set. There was an exchange of correspondence on behalf of accused number 13, whom we also represent. And on the 10th of November 2020, my lord, a J50 warrant was secured for accused number 13 and shown to us. He was in turn handed over, my lord, and the formal bail application, because it's Schedule 5, then issued on the 13th of November 2020. He was then also released on bail. So all of our clients, our two human clients, and obviously the company doesn't come into the picture, are on bail, my lord. There have been numerous, my lord, I can go through it, it's quite obvious, appearances and postponement and pre-trial conferences, exchanges of correspondence, and I can take the lordship through all the different steps that I don't believe is necessary. I can go forward, my lord, to this year, if I may, because that will be of assistance. So, my lord, there was an exchange of correspondence from the DPP's office in December of 2024 relating to the appointment of a judge from an outside court. And there was a response by the DJP in Behelis to that letter on the 17th of December 2024. And this culminated, my lord, in a pre-trial conference that was held virtually on the 20th of January of this year. And that's where I think we can start from, if you don't mind, my lord. At that virtual pre-trial, my lord, I record that the accused 9, 10 and 11 were absent. Not that they didn't have legal representatives, my lord. They didn't even appear to be aware of the pre-trial. So they weren't in attendance at the pre-trial, and that was recorded in the pre-trial. And there was then a debate pertaining to that letter, my lord, and it was explained by the state that it was sent in good faith. And the state recorded there and then that they were ready for trial, but they had caused another issue to come to the fore, and that there would be an application for at least one assessor to assist whichever judge is appointed to deal with this matter. It was then said that in that pre-trial that they bring an application for assessors timelessly, and that the presiding judge, which is the High Lordship's position,
Thank you, Mr.
to decide whether assessors were necessary or not, which is the law, my lord, in terms of the Act. Section 145 is clear on that. So there can be no doubt about that. What then happened, my lord, is that we were told in that pre-trial that accused 11 and 17 have not confirmed that they're ready for trial. I then predicted that the matter would not run. It seemed that there were companies that were also insolvent, as your lordship will get as we go down the list of accused that weren't represented by anybody, not even a physical representative nor a legal representative. We then addressed correspondence about the matter to the state on the 3rd of March 2025. They responded on the 3rd of March 2025. There's an exchange of correspondence by us again on the 10th of March 2025, and we sent them a Section 342A notice. We were told last week, my lord, that accused number 2, whose representative just seen, the previous legal representative wasn't allowed to appear before this honourable court. That person was then removed from court, and that's, I think, what caused the problem for accused number 2. I wasn't present. I followed through the press and my correspondence with Mr. Donation. Mr. Donation then told me on Friday that they were having another pre-trial, and he then sent me a message as a courtesy, and I'd spoken to Mr. Cassim as well, and they informed me that accused number 2 would not be ready for trial, and there's an exchange of correspondence. I also raised an issue with Mr. Donation concerning the relaxation of accused number 3's bail conditions should the matter be postponed for a lengthy period of time, because it seemed inevitable, because I can place on record, my lord, that we are not available in July and August of this year, because we've cleared our diaries and moved everything into July, August, for the remainder of the year, and I'm sure most of my colleagues are in a similar position. So should this matter be postponed, my Lord, I envisage that it will be to, at best, the first term, if not the second term of next year, being 2026. I need to record that. My Lord, it's the second time this matter has been set down for an entire term. It happened previously. We were meant to run in the second term of 2024, and there were other issues relating to a different co-accused. One was ill, my Lord. One was being extradited, my Lord. I can identify them to your Lordship, so we know the position. But that was the position that we found ourselves in at the time. So the problem that we had is it was clear last year at this time that the matter could not proceed, and it seems that we're in a similar position now, as I had envisaged, and I place it on record, my Lord. And I know the state keeps saying they're ready to proceed, but they haven't ensured, by way of example, that accused number 2's current legal representative has a docket to prepare, or that, and I think there's a similar position pertaining to other accused. I haven't remained in the fold as to those developments, but we are clearly prejudiced by these delays, and I place that on record. As your Lordship already highlighted, it's not the first time, it's the second time, my Lord, that we've set aside a term with tremendous cost implications, and we place it on record, my Lord, that we're prejudiced by these delays. The docket keeps growing. There were amendments to the indictment until relatively recently as well, my Lord, but that's in the nature of things, and there have been further investigations, and Mr. Donation has explained it. So I don't take any issue with the state saying that they're ready to proceed, but I think it goes a bit further than that, my Lord, to ensure that everybody is ready to proceed before one sets down the matter for an entire term for a second time. But that's my position, my Lord. We're on bail. We're ready. They haven't mentioned anything to your Lordship thus far this morning about the appointment of assessor or assessors. But that's the position we find ourselves in.
Thank you, Mr. Ouders. Do I understand you correctly that it is mainly because of the problem, or the issue of accused number 2, that you say this matter cannot proceed today? That is the main reason.
No, yes, my Lord, I think they're more accused. I'm not certain that have problems, because we weren't participating in those more recent trials of last week. But the states are aware of the positions of the other accused. I understand that there were issues relating to accused 17 and others. I don't know and the position of the companies either, my Lord. In our preparation, we saw from the diary there was some doubt about even dealing with the very next accused, my Lord, accused 5 and 6, as to who represents them in the physical form of a liquidator, trustee, or representative of those companies, and which firms of attorneys. So I don't know if that has been resolved, and that will apply. That's I'm very pleased, if I might state, my Lord, that we're doing this housekeeping to ascertain who belongs to who and who represents who in this matter. But I can record, my Lord, on behalf of accused 3, 4 and 13, we've set the time aside and we're ready, my Lord, but we envisage that it won't run.
Thank you, Mr. Anderson, and I take it for granted that you are ready to proceed for the rest of this term.
Yes, my Lord. Even in instances, my Lord, where I was offered other work, I said this took priority because I knew of my commitment here. So I've been able, fortunately, when Mr. Donation told me that the matter is not running to full certain days, but this was my first priority and remains so, my Lord, as a commitment to this honourable court. No question, my Lord.
Thank you, Mr.
Thank you.
Thank you. Accused number 4 is also presented by Mr. Ouders.
Yes, ma'am.
Accused number 5.
Number 5, my Lord, is Rambau, initials WT, RAMBAU, from Rambau, Maswara and Chauke Incorporated.
Mr.
Rambau, RAMBAU, and his initials are WT. The Lord, I appear for accused number 5, 6, 7, and 8. I wish to bring to the attention of this honorable court that we are ready to proceed with the matter. Indeed, the accused are on bail. We have presented our readiness very early when the matter was being postponed on several occasions. We were indeed ready, even at this stage, as the court.
Thank you, Mr. Rambau. You're not assisted by anybody?
No, I'm not assisted by anyone.
You appear for accused 5, 6, 7, and
8 in this one.
Thank you, sir. Thank you so much, Mr. Ambao. Accused number 9. Who's appearing for accused number 9?
May it please the Honourable Court, my Lord, I appear on behalf of accused number 9 and 10. And I must put on record that we are ready to proceed, my Lord.
First one, know your name.
Diba TD, my Lord. Diba, D-I-B-A.
Diba.
Diba. TD. Yes, my Lord.
Are your clients on bail?
He is on bail, my Lord.
Accused number 11.
Please, my lord, I appear for accused number 11. The surname is Osborne. There's been a change in instructing attorneys, my lord. The instructing attorneys are now Masons Incorporated of Pietermaritzburg.
Initials, Mr. Osborne.
B for Bravo, my lord.
What is the situation as far as accused number 11
We are ready, my lord.
is he on bail?
Mr. Zulu is on bail, that's correct. We attended a pre-trial at the end of February and indicated our readiness. We did not attend the 20th of January pre-trial as there was, as my mandate had been terminated due to attorneys changing, and my mandate was then reconfirmed by the new attorneys.
Yes, thank you for informing me, Mr. Osborne. Might I just mention that all issues that the accused are raising and the situation as far as all the accused is concerned is rather volatile because of the enormity of it, because of the many accused appearing in this case. And what the position was a week or 2 weeks ago could very well be quite different today. That is the reason why I'm going through this exercise now to find out precisely who is appearing, who is still on bail, who is here, who is not here, so that we can assess the situation and then make some informed decisions.
That's what we'll do. Thank you.
Here's number 12.
As it pleases the court, my lord, I confirm that I appear on behalf of accused number 12. My name is Machilu. My surname is Mutohu. My lord, the record will reflect that the accused number 12 was initially represented by macro attorneys and briefed Advocate Mazibu. Their mandate has since been terminated, and my services were enlisted on the 3rd of March 2025. Upon receipt of the instructions, I commenced earnestly to prepare for the matter, so as to ensure that we avoid any delays in commencing the trial. I kept the state updated with my state of readiness. To my advantage, my lord, I was previously involved in this matter, albeit representing a different accused. So I'm quite familiar with the matter, including the issues at hand. Wish to place on record that I did not attend pre-trial, obviously on behalf of accused number 12, but I have had a series of consultations with accused number 12 to ensure that when the matter commences today, we are ready. I therefore place on record unequivocally that we are ready to proceed. We are furthermore ready to plead to the charges, and accused number 12 is out on bail. I wouldn't belabor on the submissions made by my learned senior and also sentiments expressed by the Honorable Court in as far as having the matter commencing earnestly and ensuring that the matter is concluded as speedily. And for that purpose, my Lord, I would confirm that I've reserved the entire term to be available to attend to this matter as a court pleads.
Thank you, Mr. McDonald. Excuse number 13.
Lord, that's my other client, which I've addressed to Lordship on. Yes, ma'am.
Mr. Maksula.
There's your Lordship, please.
Thank you. Hearing number 14. Hearing number 14.
Morning, my Lord. A.D. Skuman. Skuman Stein attorneys, appearing on behalf of accused 14 and 15.
Thank you, Mr. Skuman. What is the type of readiness?
We are ready to proceed, both accused 14 and 15. Both accused also on bail now.
And I take it that you are available for the remainder of this day.
Indeed, sir. my Lord. As you please.
Here's number 16.
May it please the court, my lord, from Skulkwake, initials CJ, appearing for number 16 on the instructions of Grant Raymond. 16 is on bail. We are ready to commence, reserve the entire term as set out last year, and we would like to report, if the law will permit me, that we will be seriously prejudiced that this matter does not commence sometime during the course of this session. That's my time. Thank you.
Thank you, Mr. Skulkwake. You mentioned that the accused is on bail.
Yes, sir.
Is there anybody appearing for accused number 17?
May it please this honorable court, my lord. I am Loiso Macapella. Macapella. L.
Are you ready to proceed?
My lord, if I may just put my attorneys on record as well. Moragile Tebane attorneys. My lord, if I may just give a brief background to our readiness, because in addition to accused number 2, I think we were the other accused that had some problems with readiness. Up until the 20th of January, the pre-trial, the virtual pre-trial of the 20th of January, accused number 17 in the criminal proceedings was represented by a colleague. So she was getting representation from me on the constitutional litigation, but from Advocate Makubela on the criminal. He had indicated then, in January, that he was to be ready, or rather he was trying to be ready, but he was not quite sure because he had received the papers quite late. That was in October, and then further papers in November. He then, unfortunately, due to capacity constraints and other issues, had withdrawn from the matter prior to 2 days prior to the 21st of February pre-trial. And that is when I then was briefed to step into the proceedings as both accused number 17's counsel in the constitutional litigation as well as the criminal litigation.
When were you instructed to...
I was instructed the day that Advocate Makubela withdrew his...
on 19 February.
That was on 18th of February, my lord.
You were briefed on 18 February?
Yes, my lord. When Advocate Makubela had appeared on the 20th, he had informed the court that the accused number 17 was approaching the Supreme Court of Appeal, appealing the order of this court on her extradition as well as the constitutionality of the state's actions in regard to her extradition. So that is still pending. This is particularly important to note, my lord, because this court, per Yefer AJ, held that the state acted unlawfully and in contravention of international and constitutional law. So the accused feels she has to ventilate that before the Supreme Court to get that order certified. So we wish to place on record that that is still ongoing and that that will be a parallel litigation together with this criminal trial. And although one does not depend on the other, the outcome of the Supreme Court of Appeal's decision has a direct bearing on these proceedings as it relates to her extradition. However, my lord, when we appeared on the 21st of February, we informed the state that we were trying as much as we could to get through the 26,000 pages and that we would try as much as possible to be ready by April 15th, which is today. When Advocate Danielson wrote to the parties on the 11th of April, he indicated that accused number 17's position remained the same as it was on the 21st of February, which was that we would try as hard as we could to make sure that we had perused all the documents and all the necessary information and evidence in order to be ready today. We are ready to proceed, my lord. We just wish to place on record that the Supreme Court of Appeal still is ongoing.
Please inform me what is the nature of the pending proceedings in the
My lord, on in Judge Yefer's judgment, that would be paragraphs 165 and 166. He found that the United States relied on incorrect and false information that was provided by the state to extradite accused number 17. And he said this was a, quote, public interest issue and interest of justice issue, and that the state had grossly infringed international law and constitutional law. Unfortunately, he dismissed the application on the basis that it is the criminal court that should consider those issues and not his court. And that is the basis upon which the matter is going to the SCA, because it was a constitutional challenge, or rather an application for a declarator that the state acted unconstitutionally, and in failing to make that determination, that was an error of law.
What was the nature of the application that was brought before Judge Yefer?
It was a constitutional, an application for a constitutional declaration, my lord.
To
To declare the extradition unlawful.
To declare the conduct of the state as unconstitutional and invalid, and also to declare the extradition as unlawful, my lord.
You say that Judge Yever did make a decision or declarated that the extradition was unlawful.
He found that the actions were unlawful and that they grossly infringed international law and constitutional law. What he said in relation to the extradition, he said the extradition remains in dispute. That was his finding in relation thereto. And that is the basis upon which we approach the Supreme Court of Appeal to make that determination as to that extradition that remains in dispute, and also to make the constitutional declaration that we asked Judge Yever to make, which he did not.
Is all this happening on the basis of leave to appeal having been granted by Judge Yever?
My lord, it's happening on the basis of Section 17 of the Superior Courts Act, which empowers the Supreme Court of Appeal to hear an appeal directly from a court of first instance without appeal having been applied to from the court of quo, on the interest of justice point, and on the fact that it is a point of public importance.
When were the matter or the papers due? When was that submitted to the Supreme Court of Appeal?
So that is the issue that we dealt with, my lord, because when Advocate Makubela had to unfortunately leave the case, I had to put the preparation for that appeal on hold in order to fast track the readiness for this matter, because a new counsel would just not have been able to be ready or peruse the papers in time. And so the papers have been completed. The accused has perused everything, and the Supreme Court of Appeal, after these proceedings, or rather after we're done with the readiness with these proceedings, will be approached, my lord. The SCA
has not been approached.
No, my lord, but by the end of this week, the state will have been served, my lord. Everything is ready. The correspondent attorneys are also ready.
Now, say for instance, from your point of view, if you are successful in the Supreme Court of Appeal, what effect will it have on these proceedings that we are sitting with today?
Without dealing with the accused defense at length, my lord, the other point that the Honorable Judge Yever also made in his judgment was that the accused had the option of using the Section 106 defense of the CPA, which is that this court does not have jurisdiction over to try her offences based on the fact that the extradition was unlawful. And so on the receipt of the declarator from the SCA, that is the bearing upon which it will have here, because the SCA will or will have not declared that the extradition is unlawful.
The such a declaration coming from the SCA, it will mean the end, from your point of view, it will mean the end of these proceedings for your client.
Indeed, my lord.
Thank you.
Thank you, my lord. Could I please have a word on bail? My lord, accused number 17 is the only accused in this matter that has got stringent conditions attached to her bail. In fact, she was the only accused that the state opposed her release on bail. Her particular request is that the stringent conditions be relaxed. She has to report to the police station on Mondays and Fridays, and she has done so without fail every single day, or every single day that she has needed to, from her date of arrest in August, and has not demonstrated any desire to abscond or not to adhere to those bail conditions. However, we feel in the interests of equality of all accused in this matter, we would request this court that those bail conditions be relaxed, and that Ms. Charlotta have the same bail conditions as the other accused, which is that they have none, beyond just their being out on bail, because the continued need for her to report on Mondays and Fridays and to have her whereabouts confined within a specific jurisdiction within the Free State is now, it's obsolete, to say the least. One might understand why it might have been necessary in August. However, in April, with her not having demonstrated any desire to break the rules or to not adhere to her bail conditions, we feel that, and she feels in particular, that continued use or continued bail conditions are too stringent and unfair and not in the interest of justice or equality.
You told the court that you are ready to proceed.
Indeed.
I fact that accused number 17 is ready to plead to the charges.
Indeed, she is, my lord.
You look at section 186 of the Criminal Procedure Act.
Subsection
She is
F.
free to plead that this court doesn't got the necessary jurisdiction.
Indeed.
If the matter then proceeds, then the court will have to find somewhere along the way whether it has any jurisdiction to proceed against it. Thank you. Anything else?
That will be all, my lord.
Excuse me, my 18th.
Good morning, my lord. Jay Finter from Ulrich Bruin Associates in Johannesburg. Appearing on behalf of accused number 18, my lord. No, it's just Mr. Finter. Attorney Finter. And I'm unassisted. Thank you, my lord. My lord, on the aspect of readiness, my lord, we have confirmed even last year when this matter was set down for a whole term, our readiness back then to proceed. We were severely prejudiced, my client and us as a law firm, that we could not proceed last year, not due to any fault on our side. We've right through attended all the pre-trial conferences and confirmed that we are ready to proceed, that we've been instructed to proceed for the whole term that is supposed to start today. Where we are today, we are ready to plead and we are ready to proceed. I've been reserved for this whole term as well. And if this matter is to align myself with Advocate van Schalkwyk, if this matter is not to start during this term, our client and ourselves will be severely prejudiced going forward.
Is your accused on bail?
That is correct.
Thank you, Mr. Finter.
Court, please.
Jason, the court is now fully informed of the state of this trial. We know you are ready to proceed. We know you are not ready to proceed. There seems to be a real problem with accused number 2. That is the issue of late instructions received only on the 11th, that's a few days ago. My prima facie view is that we cannot postpone this case for a long period of time, as suggested by some of the counsel. Just for the sake of one or two accused to say they are not ready to proceed. What are your views?
My Lord, yes. The problem with trials of this nature is that one cannot really preempt what is going to happen at the end of the day. May I just take the court back to the beginning of this year, and what we did last year we also did this year. I wrote emails or had emails circulated to all the parties asking them, are you ready, are you not ready, what is the position, and so forth and so on. So I envisaged this problem with accused number 2 quite a while back, because he was represented, and his attorney didn't disclose that to the court. He was represented by Advocate Mazibuku of the local bar. Now, apparently somewhere along the line at the beginning of this year, they picked up problems, and Mr. Mazibuku, Advocate Mazibuku, excused himself from the matter. But then the accused went and instructed a certain Mr. Mogele. Now, Mr. Mogele appeared, God will just bear with me, the 24th and the 25th of March of this year. While he knew that he was disbarred, sucked from the role of attorney. That is why on the 24th, the Deputy Judge President asked him for his credentials, because I think it is well known by this time that he cannot appear in any court. On the 25th he came, and lo and behold, in some arrogant manner, tried to convince the court that he can appear. Well, I think there is an obligation upon the state, so I had him arrested. But in any event, the arrest is not the main problem. The main problem is the accused was misled. As the Deputy Judge President also said, he was actually conned. Now, of course, that placed him in another predicament. I'm talking about accused number 2. And then he got hold of the attorney that addressed your lordship previously. Now, it is so that the counsel that appeared in this court last Friday shouldn't have taken that brief. But that matter was not further discussed, and the matter was postponed to today. Yes, it is unacceptable, and very much so, because he should have been here to fight his own battles. Now his attorney has to stand in for this mishap, may I call it that. But the problem is, where does that leave accused number 2, in all fairness? And that is for this court to decide. I'm in total agreement. In all fairness, I think he should get a remand or postponement. I'm talking about accused number 2. But not until August or whenever. I think a reasonable time on which the court will have to decide what is reasonable. And may I just say, this docket is not 26,000 pages, it's a lot more. But in any event, I'm glad they at least read up to 26,000 pages. But I should think, in all fairness. Otherwise, we're gonna pick up huge problems in the SCA, which is it speaks for itself. If the court bluntly denies a postponement for accused number 2. But not a carte blanche. What the state is saying, give him a reasonable postponement. And the time, is in the hands of the court. But I suggest not more, and I'm very adamant about this, not more than a month. Any attorney or counsel that works hard can prepare this matter in a month. There's a lot of reading, yes, but as I said previously, there is a voluminous and all-encompassing forensic report. If you read that report with its annexures, you basically know the state's case inside out, because it takes everything together. It's basically a summary of each and every averment against these accused. It is a lot of reading, but it's a very nice summary. One of the reasons why we appointed the forensic auditors. That pertains to accused number 2. Accused number 17 is a different kettle of fish. I find it very strange that my colleague stands up here this morning and says that they are ready to proceed with this criminal trial. I'm saying this because they were one of the team of defense attorneys and advocates that did not answer to the mail that I circulated. That is why I called Mr. Dibani, the instructing attorney, last week. He didn't answer my call. He called me back the next day. And I specifically asked him, what is the position? You didn't answer me. Are you ready, or is it still the same position as what it was in February? And I'll tell the court what they placed on record in February. That what my colleague said is not correct. And he told me last week, as in Thursday, that they will not be ready. And they will not be ready anywhere in this term. That is why I sent another mail informing all the other parties of the predicament of accused number 2 and the problems with accused number 17. So the state was misled. It's just clear as daylight. What my colleague furthermore says, that they placed on record in February that they will do their utmost to be ready for today, is false. She said pertinently, and we can look at the record, they will not be ready. They will not be ready because it's too much reading, too much preparation, counsel has changed, and. So, my remarks were, afterwards, that it is a pity that the presiding judge postponed the matter then and there to today, instead of just giving another pre-trial date to hear how far they have prepared. But, so it hanged in the air. I'm very surprised and, of course, glad that they are now ready to proceed. It takes away half of the issue. But I'm just worried about the ethics. Pertaining to these applications that they lodged, and there's not only one, I'm going to ask my colleague, Advocate Fries, to address you on that, because it is motion applications in nature, and she handled it on behalf of the state. But again, what my colleague indicated to the court is not correct. And that's a worrying fact. But may I ask my colleague to address you on that issue? Because I think it's very important what the position is with that application to the Supreme Court of Appeal. Because that's one of the factors that this court will have to consider today. Thank you.
My Lord, before Ms. Fries addresses you, may I just make one observation, my Lord. My Lord, as far as accused number 2 is concerned, it is significant to point out to your Lordship, at the relevant time and at the present time, he is the manager in charge of chain management policy. Your Lordship knows in the main matter, the contention of the state is a contract was given for over 250 million. 250 million was paid. Further subcontracted for 5 million. Greece subcontracted for 23 million. All wasted. The very man who's in charge of procurement, my Lord, with great respect, procures an attorney who struck off the roll. The same person, when your Lordship is assessing reasonableness, when he's informed, but your attorney is struck off the roll, procure counsel who is not available. And the address by my learned friend for accused number 2 is really an affront to the dignity of the court. My counsel is briefed, who is not available to run the trial, knowing the prejudice to 17 other accused, knowing the overwhelming prejudice to the fiscus and the public at large. My Lord, I will submit to your Lordship, when you're assessing reasonableness, my Lord, nothing stops your Lordship from managing the trial to say, we can start the trial to the extent that the prejudice in preparation at the relevant time, your Lordship can stand it down. The difficulty is, my Lord, my Lord, the accused hasn't procured a counsel who's available today. But your Lordship will take that into account. I had to make that point in the public interest.
Thank you.
That's your Lordship.
Physical pleas, my Lord. In respect of the interlocutory application for a declarator about the constitutionality of the extradition of accused 17, the judgment of Judge Heerfer that my learned friend referred to was handed down on the 23rd of January 2025. As my learned friend has informed the court, there was no application for leave to appeal pursued in respect of that judgment, and that remains the position today. My reading of Section 17 of the Superior Courts Act, as well as Section 16, makes that compulsory before an application to the SCA can be proceeded with. That has not happened. To the extent that my learned friend has now told the court that there is no pending application before the SCA as we stand today, that is correct. The state has not received any such application. If an application were to be pursued, it would be well out of time by now. We're nearly 3 months later from that day. We have informed through correspondence, which would have happened, I don't have the dates unfortunately with me, but in February after the judgment was handed down, that the correct procedure would have been to apply for leave to appeal. That was seemingly ignored. We were informed by the attorney for accused 17 that they are preparing the record for the Supreme Court of Appeal, but that is of course incompetent procedure under the Superior Courts Act without leave having been granted. In short, as we stand today, there is no pending application for leave to appeal. There is no pending application before the Supreme Court of Appeal. And there was no finding made in the judgment of Heerfer as to unconstitutionality or unlawfulness. In fact, in paragraph 171 of the judgment, the learned judge said, presently, however, it appears that the constitutionality and therefore the lawfulness of the extradition of the applicant remains in dispute. That is as far as the judgment went, and as my learned friend stated, the application was dismissed with cost. So, as we stand today, there is no pending application before the Supreme Court of Appeal, and the state will submit that that would not be or ought not to be a reason to grant a postponement or delay the matter insofar as that accused is concerned.
Thank you.
May I just, something that I neglected to tell the court. There is the issue of this assessor that the state wanted. We already informed the Judge President as in the end of last year that we are intending to request or apply for an assessor to assist the presiding judge. It's only my colleague Houders that addressed this issue to some extent, but I know there was opposition from Mr. Houders as well as from Mr. van Skalk. bluntly, I put some lines in the water in the meanwhile to find out the availability of assessors. I was specifically looking for possibilities in the sense of persons that were retired and so forth. I couldn't find anyone retired at this stage. But what worries me, my lord, is whether we are ever going to get an assessor, because of the fact that the state or the Department of Justice only pays 1,000 rand a day. I must say, when I got that mail from the office manager in this court, I found it hard to believe, but apparently it is a fact. So I don't know who in his right mind will be prepared to work for 1,000 rand a day, and that's before tax. So if the court now today decides that this case, this trial should proceed, which is of course the first prize for everyone, especially the state, then I intend to withdraw my application for an assessor, because I don't think, first place, we're going to get one who's going to be prepared to appear or sit with your lordship for, say, 750 rand a day. So, yeah, that's, and of course this is going to take weeks and months, even years. So I think the practicality thereof, even a retired person will not be prepared to appear for those fees.
Yes. Mr. Mason, if you say to me that you are withdrawing your suggestion that an assessor should be appointed, then there is no need for you to go further into that question. But looking at Section 145 of the Criminal Procedure Act, it seems to me that if there is a request now that an assessor be appointed, that request is premature. Because Section 145 clearly says the following, namely, an assessor for the purposes of this section means a person who, in the opinion of the judge who presides at the trial, has experience in the administration of justice and so forth. But subsection 2 provides as follows: where an Attorney General arraigns an accused before a superior court, firstly, for trial and the accused pleads not guilty, or for sentence or for trial and the accused pleads guilty and the plea of not guilty is guilty. So it seems to me the question whether an assessor should be appointed will only become relevant after the accused has pleaded not guilty.
Yes.
So to make such a request or to make such a suggestion before any of the accused have even pleaded is, in my view, simply premature.
It is a question, my lord, I absolutely hear what your lordship is saying, but it is a question of trying to preempt and to avoid a delay, a further delay. Because if I stood up today for the first time informing the High Court of the Free State Division that the state intends to ask for an assessor, it would have come as a surprise and would have most definitely caused a delay, which it now in any event will cause. But what I'm saying is, if the court grants a postponement to accused number 2, and it is for 3 weeks or even 2 weeks, the court can still make the determination that the court wants an assessor. We are of the view it can be of assistance to your lordship, but it is ultimately your lordship's decision. If your lordship feels that an assessor is not necessary in this case, then so be it. And I also indicated previously to other presiding judges that we will not pursue it any further. If your lordship makes a ruling that, listen, I don't need an assessor, then it's the end of the matter. But if this matter is postponed, the court can make that final decision and decide. But what I'm saying is, if the court denies or refuses any postponement on behalf of accused number 2, then I don't want the case to be delayed because of an application for an assessor. Then, in those circumstances, I shall withdraw my application. Everything just to get this trial running. That is the the bottom line. But the application is now there. If the court decides the court wants this assessor, then so be it, and it's going to cause a delay.
Can I just add? Can I just mention this information? There was a suggestion, there was talk of the state suggesting the identity of the assessor, and I believe that the state says that, or said that, with the intention to assist the court.
Yes.
But let me say quite straightforward. I'm not likely to take any suggestions from the state as to the identity of the assessor. That would make the accused feel uncomfortable.
Of course.
And I don't want to happen that. I want this court to provide them with a fair trial before this day. So if the decision is there in the end, or in the beginning, that an assessor should be appointed, then it is the presiding judge who should decide on that. And then the presiding judge should also take into account, as it was stated before, the enormity of this matter. I do not think, having regard to all the evidence that will be led to the fact that there are 18 accused, I want to view that this matter will take many months, if not more than a year or 2 years, to bring to finality. And to bring an assessor in such a complex, long matter that could last very long. At this stage, I'm really not inclined to appoint any assessor and to make a ruling that this matter should proceed as we said today.
100%, my lord. That is why I just want to clarify. That is why I specifically stated in the papers when I applied formally applied for the appointment of an assessor that it is the decision of the court, and if an assessor is appointed, we'll only make suggestions. What I said was, when I threw out the lines hypothetically, it was just to test the waters. Will someone be prepared? And I haven't found one that will be prepared. So, but if I understand your lordship correctly, now the assessor issue has been disposed of.
Yes, I think I must bring finality to this issue.
As it
I make a ruling now.
Yes.
This court will proceed sitting with one judge as it is now. No assessors or assessors will be appointed.
100%. Thank you, ma'am.
Mr. Mason, there's another issue before we proceed further. That is, there is apparently an application by some of the accused that this court should find that there was an unreasonable delay on the part of the state in the prosecution of this matter. For that reason, the charges against them should be squashed. Are you aware of it?
No, I'm not. But it's been the narrative all along. And I have stated it ad nauseum. We were ready last year. We were even ready before that. In April last year, when the trial was set down, accused number 17 had not yet been extradited from America, but we were prepared to carry on without her. Then one accused had to be hospitalized and another had some problems and so forth. So, very important. And this is very important to note, that the state was not the reason for the remand in April 2024. That is the reasons why we circulate these emails, to ensure that everybody is right, or is ready. How the state can be blamed for an attorney appointing an advocate on a double brief, I don't know. I fail to see. It is so convenient to blame the state for each and everything that happens in this trial. That is why I specifically said, because I'm waiting for that kind of response. Yes, the state now arrested an attorney. The poor accused number 2 is now, we left him without an attorney. The fact is, my lord, he wasn't in any event going to be able to appear in this case. So, how the state can be blamed in each and every instance, I don't know. But rest assured, and this is extremely important, if the court denies this request for postponement, I put the charges to the accused immediately. Especially now that the assessor issue is out of the way. And directly thereafter, if there's not some other applications or whatever, I call the first witness. That is as simple as that is where we are. That is how ready the state is. And we were in this precise position last year in April. The only difference now is that accused number 17 has been extradited, and she's now part of the trial. So everybody's here and everybody's ready except accused number 2.
Yes, thank you, Mr. President. Can I just find out, are there any of the accused who wants to proceed with this application for the finding that there was unreasonable delay on the part of the state? Are there any of them?
My Lord, we had submitted that application that your Lordship refers to on behalf of accused 3 and 4. It was premised, my Lord, on the basis of the state at the very late stage, being December last year, proposing assessors. Your Lordship has dealt with that matter, so I consider it has been discharged and final, and we will not be proceeding with it any further, my Lord. If I can explain our conduct, my Lord, what happened was we had numerous pre-trials, as I said to your Lordship. I can give your Lordship the dates, I don't believe it's necessary. At no stage was the appointment of assessors ever canvassed. I, with respect, agree 100% with your Lordship in relation to the stage at which assessors ought to be appointed in terms of section 145. That's after the plea of not guilty or after the plea of guilty and before sentence is imposed. It isn't going to be the case here, fortunately. So we're looking with respect, as I understand, to pleas of not guilty. They haven't occurred as yet. We had numerous pre-trials. There was no mention in any of those pre-trials of the appointment of an assessor. It arose late. I understand that matter is discharged, and we will not proceed at this stage with any 342 application premised on that. I also need to confirm as an officer of the court that everything that Mr. Donation informed your Lordship, he kept us abreast of through the process, my Lord. We were kept abreast of all the process of who was ready, not ready, and as he explained it to your Lordship, how it was explained to us. We were of the view, my Lord, that the introduction of the assessors would cause a further delay. If that's been abandoned, we abandon the matter.
Thank you. If I may, we've also filed a notice, the Lord will remember, that has now been underpinned by the developments, and in fact, my Lord had conducted inquiry today through the process that we've done now in the premises that become superfluous. It's not proceeded. Thank you.
Yes, gentlemen, I must inform that I've looked at this matter carefully as well as I could, and there can be no doubt that there has been delays in bringing this matter to where we stand today. There were delays on the part of the state, but I'm of the opinion that can be explained, having regard to the enormity of the case, of the many charges, the many accused, and the complexity of the case. This is the type of case which the state can be expected to bring before a court in a week or 2 weeks' time. On the other hand, there were many delays caused by the accused themselves. In some instances, those delays caused by the accused were not the fault of themselves. And in the premises, I formed the opinion that we cannot, we should not waste time to point fingers to any delays, and therefore I appreciate the attitude of Mr. Hodis, also Mr. Starkwick, if I'm not mistaken, to let go of the application for the finding that there was unreasonable delay. Then the particular section says, if it appears to the court that there were unreasonable delays, and from the beginning it didn't appear to the court that there were unreasonable delays. So I regard that matter as being put to bed, and we will not proceed any further with that issue. Now, there are basically primarily 2 accused who say that they are not ready to proceed. But it is my view that this case must proceed. We cannot postpone, and in 2 months' time we sit in the same position, and in 6 months' time we sit in the same position again. That is not in the interest of justice, and it's not in the interest of the accused themselves. I'm therefore of the opinion, and I will ask any of the council who wants to comment on it, and therefore of the view that we should, as a next step, now proceed with putting the charges to the accused one by one and let them plead to them, so that the lines can be drawn and that we can work on that forward. Accused number 1, his legal representative, Mr. Piper, has informed the court that they are ready to proceed, for instance. And what I would prefer to do is to ask Mr. Mason to put the charges to accused number 1 and to but then, when we come to accused number 2, I do not see the necessity for any legal representative of accused number 2 to have an opportunity to study 26,000 papers in order for him to plead. All of the accused must plead in terms of the provisions of section 106. That is, if he is guilty, or if he is not guilty, or that they have been found guilty of specific charge previously, and so forth. It is a simple question as to what they plead. And as far as accused number 2 is concerned, Ms. Mahona, you can certainly, and I will give you time to do it, I will give you half an hour if you need it, to approach your client accused number 2 and ask him what the plea will be. Is there a plea of guilty? Is there a plea of not guilty? So that I can enter that plea and that we can then move forward from there. Do you need any opportunity to consult with the Appeals number 2?
Yes, my Lord. Yes, my Lord. We will need the opportunity to consult with the Appeals number 2.
Yes, and as far as Appeals number 17 is concerned, Mr. Makapela.
Ms. Makapela, my Lord.
Oh, sorry. The Lord Appeals is the one who seems to rely on future findings on the Supreme Court Appeals. But after having heard his pleas on behalf of the state, I want to confirm with you that there is presently no application for you to appeal to the Supreme Court of Appeal on behalf of your client.
My Lord, I think we were quite clear with that, which causes confusion as to why Ms. Fries felt the need to inform this court once again. But we did clarify that there is no application, and that the reason for that is because we had to set that aside to prepare for this case, but that would still be going ahead because after all, there are applications for condemnation. And so that is indeed the case.
Thank you, but Ms. Makapela, that would not, for instance, preclude accused number 17 to plead not guilty on the basis that this court doesn't have the jurisdiction.
Not at all, my Lord, not at all, which is why we informed that we are ready to proceed.
Yes, thank you. The court will then adjourn for half an hour. Let us make it 12 o'clock. Then we will proceed with the plea process. All right.
on their behalf unlawfully, falsely, and with the intent to defraud, explicitly or tacitly, through words or conduct, and or fail to act, pretended to the Department of Human Settlements and or Treasury Department and or the state that the contract between the Department of Human Settlements Free State and accused 3, 4, and 5 and subcontracts between accused 3, 4, and 5 and accused 7, 8, 9, and 10 were legitimate contracts in terms of the policies, procedures, prescripts, and legislation as outlined in the preamble, and or the contract between the Department of Human Settlements Gauteng and accused 3, 4, and 5, on which the Free State contract was based and which made it possible to implement the same concept in the Free State, was a legitimate contract in terms of the policies, procedures, prescripts, and legislation as outlined in the preamble, and or all proper procurement processes as prescribed by legislation, guidelines, and policies as outlined in the preamble were followed in awarding the contract to accused 3, 4, and 5 in Gauteng and or the Free State, and or accused 1, 2, 11, 12, 13, and 18, and all persons directly or indirectly associated with them had no personal or financial interest in the awarding of the contract to accused 3, 4, and 5, and or accused 7, 8, 9, and 10, and or all monies paid over and received by to accused 3, 4, and 5, and or accused 7, 8, 9, and 10 were legally due and not subject or result of any unlawful practices, and or the work that formed the basis of the contracts was completed and or done properly and cost effective, and or the department received value for money, and or accused 3, 4, and 5 was entitled to and could legally subcontract with accused 7 and 8 without disclosing such fact to the department, and or accused 7 and 8 was entitled to and could legally subcontract to accused 9 and 10 without disclosing such fact to the department, and or to accused 3, 4, and 5 and or accused 7, 8, 9, and 10 were entitled and or allowed by law to conduct the work in respect of asbestos stipulated in the contracts, and or no prices and or fees were inflated, and or no stipulations of the contract were altered, and or whereas the accused, when they made such representations individually or collectively, and or together with representatives and or unknown individuals acting on their behalf, knew that the contract between the Department of Human Settlements Free State and accused 3, 4, and 5 and subcontracts between to accused 3, 4, and 5 and or accused 7, 8, 9, and 10 were illegal and irregular, and or the contract between the Department of Human Settlements Gauteng and accused 3, 4, and 5 was illegal and irregular, and or the contract between Human Settlements Gauteng and accused 3, 4, and 5 could not be used as a basis for the implementation of the same contract and or concept in the Free State, and or proper procurement processes as outlined in the preamble were not followed and adhered to, and or accused 1, 2, 11, 12, 13, and 18 had personal or financial interest in the awarding of the contracts in Gauteng and the Free State, and or the payment of 230 million to accused 3, 4, and 5 and subsequent payments by accused 3, 4, and 5 to accused 7 and 8 and by accused 7 and 8 to accused 9 and 10 were not legally due and or were the result of unlawful practices, and or the work was not done properly and or completed and was not cost effective, and or accused 3, 4, and 5 and or accused 7, 8, 9, and 10 were not entitled and or allowed by law to conduct the work as stipulated in the contracts, and or accused 1 and or 2 and or 11 were not entitled and or allowed to appoint accused 3, 4, and 5, and accused 3, 4, and 5 not entitled and or allowed to subcontract accused 7 and 8 and or accused 7 and 8 to subcontract accused 9 and 10 and/or had to disclose such facts to the department, and/or the contract price was inflated from 650 Rand per house to 850 Rand per house, and/or discrepancies existed regarding the services to be rendered in terms of the contract. The unsolicited proposal and the letter of appointment created the impression that the appointment was for the assessment, removal of asbestos material, and the replacement of asbestos roofs. The service level agreement only referred to assessment and removal. The instruction to perform work was only issued for the assessment, whereas the contract price remained the same. And through the aforementioned misrepresentations and/or omissions, the accused individually and/or collectively persuaded the Department of Human Settlements and/or the Treasury Department and/or the state to its actual or potential prejudice to award the contract as outlined in the preamble and to pay an amount of 230 million on the dates stated in the preamble of a total contract amount of 255 million Rand to the accused as outlined in the preamble. My Lord, that is the main count. There are then quite a few alternatives.
Mr. Mokgesi, understood the count 1 up to 8 against you. What do you plead to those counts? Not guilty. We can then move on to the first alternative.
As it is in the court, my Lord. The first alternative to count 1 to 8 being theft, in that at the time and place mentioned in the main count, the accused unlawfully and intentionally stole 230 million Rand, the property of the state.
You understood this charge, Mr. Mokgesi. What do you plead to the charge?
Thank you, my Lord. The second alternative of count 1 to 8 being attempted theft, in that at the time and place mentioned in the main count, the accused unlawfully and intentionally attempted to steal 25 million Rand, the property of the state.
You understand that charge against you, Mr. Mokgesi, and you plead? Okay.
Thank you, my Lord. The third alternative, my apologies, count 1 to 8, is failure to report corrupt transactions, contravention of Section 34 of Act 12 of 2004, that the accused are guilty of the crime of corruption in contravention of Section 34, 1, paragraph A and or paragraph B and or Roman numeral 4, read with Sections 1, 2, 20, 21, 24, 25, 26, 34 subsection 2 and 34 subsection 4 of the Prevention and Combating of Corrupt Activities Act 12 of 2004. In that at the time and place mentioned in the main count, the accused who held positions of authority as outlined in the preamble and who knew or ought reasonably to have known or suspected that any other person has committed A. an offence under Part 1, 2, 3 or 4 or Section 20 or 21 in as far as it relates to the aforementioned offences of Chapter 2, or B, the offence of theft, fraud, extortion, forgery or uttering a forged document, involving an amount of 100,000 Rand or more, directly or indirectly and individually or collectively, wrongfully and corruptly failed to report such knowledge or suspicion or cause such knowledge or suspicion to be reported to the police official in the Directorate for Priority Crime Investigation, referred to in Section 17, capital C of the South African Police Service Act 68 of 1995, in that they knew or ought reasonably had to have known or suspected that one or more of the crimes listed above were committed by any persons in the awarding of the contract and payments to accused 3, 4, 5, 7, 8, 9, and or 10, which involved more than the amount of 100,000 rand, namely 255 million rand, and failed to report such knowledge or suspicion.
You take the note of the third alternative documentation, and you will plead to that. Thank you.
Thank you, my Lord. Count 9, corruption, contravention of Section 3 of Act 12 of 2004, only against accused 1. That the accused are guilty of the crime of corruption in contravention of Section 3A, Roman numeral 2, and or Roman numeral 3, and or Roman numeral 4, read with Sections 1, 2, 20, 24, 25, and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004, in that on or about the 2nd of April 2015 and at Bloemfontein, in the district of Bloemfontein, the accused directly or indirectly and wrongfully and corruptly accepted and or agreed and or offered to accept any gratification, namely payment of 650,000 rand paid on his behalf to Kramer, Weyeman and Joubert attorneys, which was not legally due from accused 3 and or 4 in order to act or omit to act personally and or by influencing another person to act in a manner that amounts to abuse of a position of authority and or a breach of trust and or the violation of a legal duty or a set of rules, and or which was designed to achieve an unjustified result, and or that amounted to any other unauthorized or improper inducement to do or not to do anything. In that accused 1 unlawfully and intentionally manipulated the process of the appointment of accused 3 and or accused 4 and or 5 to ensure that the contract is awarded to accused 4 and or 5.
You understand this, Council President? Thank you, please. Thank you.
Indeed, so, my Lord. Alternative count 9, corruption, contravention of Section 4 of Act 12 of 2004, again, also only against accused number 1, that the accused are guilty of the crime of corruption in contravention of Section 4.1a, Roman numeral 1, and or Roman numeral 2, and or Roman numeral 3, read with Sections 1, 2, 4 subsection 2, 20, 24, 25, and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004. In that during the time and place mentioned in the main count, the accused was employed as the head of the Department of Human Settlements, and as such a public officer, directly or indirectly and wrongfully and corruptly accepted and or agreed and or offered to accept a gratification from accused 3, 4, or 5, whether for the benefit of himself or for the benefit of another person, namely payment of 650,000 on his behalf, in order to act personally or by influencing another person so to act in a manner that, Roman numeral 1, amounts to the illegal, dishonest, unauthorized, incomplete, or biased, or misuse or selling of information or material acquired in the course of the exercise, carrying out, or performance of any powers, duties, or functions arising out of constitutional, statutory, contractual, or any other legal obligation that amounts to the abuse of a position of authority and or a breach of trust and or the violation of a legal duty or a set of rules designed to achieve an unjustified result and or that amounts to any other unauthorized or improper inducement to do or not to do anything.
I understand this alternative charge against you, and you please. Thank you.
Just the court's indulgence, my apologies, my lord. My lord, if we may then turn to page 62. My apologies, my lord, just one moment. Thank you, my Lord. If we may then turn to page 62 of the indictment, and this refers to count 20, contravention of section 86 of the Public Finance Management Act, Act 1 of 1999, that the accused is guilty of contravention of section 86, regular sections 1, 2, 3, 36 and 38 of the PFMA, or the Public Finance Management Act, in that during the period 2014 to 2016 at Bloemfontein, in the district of Bloemfontein, the accused on whom a legal duty existed in terms of section 38 to A, ensure that the Department of Human Settlements has and maintains effective, efficient and transparent systems of financial and risk management and internal control and or Roman numeral 3, an appropriate procurement and provisioning system which is fair, equitable, transparent, competitive and cost effective, and or B, is responsible for the effective, efficient, economical and transparent use of the resources of the department, and or C, must take effective and appropriate steps to Roman numeral 2, prevent unauthorized, irregular and fruitless expenditure and losses resulting from criminal conduct, and or Roman numeral 3, manage available working capital efficiently and economically, and or D, is responsible for the management, including the safeguarding and the maintenance of assets, and for the management of the liabilities of the department, and or G, on discovery of any unauthorized, irregular or fruitless and wasteful expenditure, must immediately report in writing particulars of the expenditure to the relevant treasury, and in the case of irregular expenditure involving the procurement of goods and services, also to the relevant tender board, and or L, must take into account all relevant financial considerations, including issues of propriety, regularity and value for money, when policy proposals affecting the accounting officer's responsibilities are considered, and when necessary, bring those under considerations to the attention of the responsible executive authority, and or must comply and ensure compliance by the department with the provisions of this act, unlawfully failed to act as stipulated in the act.
Count 20 was the what do you plead to that?
The court pleases, my Lord. Then in relations to count 21 to 80, contravention of section 4 A and or B, read with sections 1 and 8 of the Prevention of Organised Crime Act 121 of 1998, namely money laundering, in that the accused knew or reasonably ought to have known that the property, namely the amounts of money and or payments mentioned in counts 1 to 19 and 84 to 94 and annexure A to Q, was or formed part of the proceeds of unlawful activities, namely the offences mentioned in counts 1 to 19 and 84 to 94. And that on the times and places mentioned in counts 1 to 19, 84 and 94, and annexure A to Q, the accused unlawfully entered into any agreement or engaged in any arrangement or transaction with anyone in connection with the property, and specifically the agreements, arrangements or transactions mentioned in counts 1 to 19, 84 to 94 and the preamble, whether such agreements, arrangement or transaction is legally enforceable or not, and or B, performed any other acts in connection with such property, whether it is performed independently or in concert with each other or other persons, and specifically the acts mentioned in counts 1 to 19, 84 to 94 and the preamble, which had or was likely to have the effect of concealing or disguising the nature, source, location, disposition or movement of the said act, or the ownership thereof, or any interest which anyone may have in the respect thereof, and or enabling or assisting one or some of the accused and or other people unknown to the state who had committed or were committing an offence, whether in the Republic or elsewhere, namely the offences mentioned in count 1 to 19 and 84 to 94, and or to avoid prosecution, and or to remove or diminish the said property acquired directly or indirectly as a result of the commission of the said offence. My Lord, this is then read with regards to counts 1 to 28 as well as count 63. And that refers to Annexure A as well as Annexure G of the schedule attached to the indictment.
Yes, Mr. Mokiki, you understand the counts 21 to 80 against you. You understand? And what do you plead to those counts? Not you.
My Lord, then if we turn to count 92, which is on page 83 of the indictment, contravention of section 3 of Act 12 of 2004, only respectfully against accused number 1, that the accused are guilty of the crime of corruption in contravention of section 3A, Roman numeral 2 and or Roman numeral 3 and or Roman numeral 4, read with sections 1, 2, 20, 24, 25 and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004, in that during the period November 2014 and March 2015 at Bloemfontein, in the district of Bloemfontein, the accused directly or indirectly and wrongfully and corruptly accepted and or agreed and or offered to accept any gratification, namely payment of 5 million rand, which was not legally due from accused 3 and or 4 and or Ignatius Mpambani and or accused 5 in order to act and or omit to act personally and or by influencing another person to act in a manner that amounts to abuse of a position of authority and or a breach of trust and or the violation of a legal duty or set of rules, and or which was designed to achieve an unjustified result and or that amounted to any unauthorized or improper inducement to do or not to do anything, in that accused 1 unlawfully and intentionally manipulated the process of appointment of accused 3 and or accused 4 and or 5 and or to ensure that the contract is awarded to accused 4 and or 5.
You understand count 20, count 92, Mr. Mokiki. Thank you, please. Thank you.
Thank you, my Lord. There's also an alternative to this particular count. The alternative count to count 92, corruption, contravention of section 4 of Act 12 of 2004, that the accused are guilty of the crime of corruption in contravention of section 4, 1A, Roman numeral 1 and or Roman numeral 2 and or Roman numeral 3, read with sections 1, 2, 4, subsection 2, 20, 24, 25 and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004, in that during the time and place mentioned in the main count, the accused, who was employed as a head of Department of Human Settlements and as such a public officer, directly or indirectly and wrongfully and corruptly accepted and or agreed and or offered to accept a gratification from accused 3, 4 and or Ignatius Mpambani and or accused 5, whether for the benefit of himself or for the benefit of another person, namely payment of 5 million rand in order to act personally or by influencing another person so to act in a manner that amounts to the illegal, dishonest, unauthorized, incomplete or biased or misuse or selling of information or material acquired in the course of the exercise, carrying out or performance of any powers, duties, or functions arising out of a constitutional, statutory, contractual, or any other legal obligation that amounts to the abuse of a position of authority and or the breach of a trust and or the violation of a legal duty or set of rules designed to achieve an unjustified result and or that amounts to any other unauthorized or improper inducement to do or not to do anything.
I take this alternative charge for questions. Thank you, please. Thank you.
Thank you, my Lord. Then those are all the charges levelled against accused number 1.
Thank you, Mr. Piper.
My Lord, I confirm that the accused plea on these charges and the alternatives are in accordance with my instructions, and the accused waives his right to explain his plea at this point in time. That's the court.
Thank you, Mr. President. Is accused number 2 ready to plead?
Yes, my Lord. Accused number 2 is ready to plead.
Thank you. I'm going to put the charges to you.
Thank you, my lord. With regards to count 1 to 8, the fraud, they are the same counts that have already been read. I'm not sure if I must reread them into record for purposes of accused number 2.
Really, accused number 2, really. As you heard, and have you taken note of the charges 1 to 8 that were read out to accused number 1 next to you?
Yes.
Is it necessary for the state to repeat it and to read it out to you as well?
Yes, sir.
Thank you, Mr. Matakala. My question is, what do you plead to charges 1 to 8?
From charge 1 to 8, I plead not guilty, my lord.
There was a first alternative read out to accused number 1 in relation to counts 1 to 8. Do you want to start to read it out to me, the first alternative?
Yes, my lord.
What do you plead to the first alternative?
I plead not guilty, my lord.
Also a second alternative and a third alternative, if I can take them together. Please stop me if you want me to deal with them one by one. But there was a third and a second and a third alternative. Have you read them?
Yes, I've read them.
And what do you plead to each of them?
I plead not guilty, my lord.
For both?
Yes, not guilty.
Thank you.
Thank you, my lord. Then the next counts which are applicable on accused number 2 relate to counts 21 to 28 relating to the money laundering charges, which is also then read with Annexure A attached to the indictment.
That is page
63 as well as 92 is where the annexure is attached, my lord. So 63 of the actual indictment. 92, my lord.
Are you aware, Mr. Sala, of the contents of counts 21 up to 80 against you?
Yes, I'm aware.
And you are pleading what on those counts?
I'm pleading not guilty, my lord.
On all of them?
On all of them.
There are no alternatives to counts 21 to 80.
No, my lord, there are not.
So we move on to count 92.
No, my lord, that is then all with regards to accused number 2. Indeed, sir, my lord. Indeed, sir, my lord.
Your worship, I confirm accused number 2-3, your worship, my lord, and further confirm that he makes his statements without indicating the basis of his defense.
And please that he tendered are in accordance with his instructions.
Yes, the plea is in accordance with my instructions, my lord.
Thank you, Mr. Kara. You might be seated. Accused number 3.
Thank you, my lord. We are in the same position with regards to counts 1 to 8, as well as the first and the second alternative thereto. Accused 3 is not charged with the third alternative. I'm not sure if it is necessary that I read the same into record, as it pleases the court.
Toby, have you heard count 1 to 8 was put to both number 1 and number 2?
Yes, I have.
You must please let me know if you do not know where you are as far as those counts are concerned, then I will tell the court to repeat them to you. But are you happy that you know the contents of those counts?
Yeah.
Thank you. Do you plead to those counts 1 to 8?
Not guilty.
Have you also taken note of the first and the second alternatives to count 1 to 8?
Yes, I have.
What do you plead firstly to the first alternative?
Not guilty.
And the second alternative?
Not guilty as well.
Thank you, my lord. If we may then move to page 36 of the indictment, and this is in relation to count 10, corruption, contravention of section 3 of Act 12 of 2004, that the accused are guilty of the crime of corruption in contravention of section 3b, Roman numeral 1, and or Roman numeral 2, and or Roman numeral 3, and or Roman numeral 4. Read with sections 1, 2, 20, 24, 25, and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004. In that during the time and place mentioned in count 9, the accused directly or indirectly and wrongfully and corruptly gave or agreed to or offered to give to any other person any gratification, whether for the benefit of that other person or for the benefit of another person, namely the amount of 650,000 rand paid from the account of accused 4, of whom accused 3 is the sole director as part payment for the purchase of a house by accused 1, in order to act and or omit to act personally and or by influencing another person to act in a manner that amounts to the illegal, dishonest, unauthorized, incomplete or biased, or misuse or selling of information or material acquired in the course of the exercise, carrying out or performance of any powers, duties or functions arising out of a constitutional, statutory, contractual or any other legal obligation that amounts to the abuse of a position of authority and or a breach of trust and or the violation of a legal duty or a set of rules designed to achieve an unjustified result and or that amounts to any other unauthorized or improper inducement to do or not to do anything, in that accused 3, 4, and 5 unlawfully and intentionally paid 650,000 rand on behalf of accused 1 as part payment for a property purchased by accused 1 after accused 1 participated and or assisted in the appointment of accused 3, 4, and 5 as service provider for the Department of Human Settlements, of which accused 1 was the head of department.
So the count number 10 was now read out to you. Have you heard it?
Yes.
Have you understood it? How do you plead to that count? Thank you.
Thank you, my lord. There's also an alternative to this particular count. Alternative count to count 10, corruption, contravention of section 4 of Act 12 of 2004, that the accused are guilty of the crime of corruption in contravention of section 4(1)(b), read with sections 1, 2, 4 subsection 2, 20, 24, 25, and 26 of the Prevention of Combating of Corrupt Activities Act 12 of 2004. In that during the time and place mentioned in the main count, the accused directly or indirectly and wrongfully and corruptly gave or agreed or offered to give any gratification to a public officer, namely accused 1, whether for the benefit of that public officer, namely accused 1, or for the benefit of another person, namely payment of 650,000 rand on his behalf in order to act personally or by influencing another person so to act in a manner that amounts to the illegal, dishonest, unauthorized, incomplete or biased, or misuse, breach of trust, and or the violation of a legal duty or set of rules, designed to achieve an unjustified result, and or that amounts to any other unauthorized or improper inducement to do or not to do anything.
You understood this alternative to count 10, Mr. Sweden?
Yes.
Plead
Not guilty.
Thank you.
Thank you, my lord. We then move to count 12 on page 40 of the indictment, corruption, contravention of section 3 of Act 12 of 2004, that the accused are guilty of the crime of corruption in contravention of section 3b, Roman numeral 1, and or Roman numeral 2, and or Roman numeral 3, and or Roman numeral 4, read with sections 1, 2, 20, 24, 25, and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004. In that during the time and place mentioned in count 11, the accused directly or indirectly and wrongfully and corruptly gave or agreed to or offered to give any other person any gratification, whether for the benefit of that other person or for the benefit of another person, namely the amount of 600,000 rand paid from the account of accused 4, of whom accused 3 is the sole director, as part payment for a vehicle bought by accused 11 in order to act and or omit to act personally and or by influencing another person in a manner that amounts to the illegal, dishonest, unauthorized, incomplete, or biased, or misuse or selling of information or material acquired in the course of the exercise, carrying out or performance of any powers, duties, or functions arising out of a constitutional, statutory, contractual, or any other legal obligation that amounts to the abuse of a position of authority and or a breach of trust and or the violation of a legal duty or set of rules designed to achieve an unjustified result and or that amounts to any other unauthorized or improper inducement to do or not to do anything. In that accused 3, 4 and 5 unlawfully and intentionally paid 600,000 rand on behalf of accused 11 as part payment for a vehicle for accused 11 after accused 11 participated and or assisted in the appointment of 3, 4 and 5 as service provider for the Department of Human Settlements, of which accused 11 was a Director General.
You understand count 12 against you, Mrs. Ali? I do. And you plead, what does it? Thank you.
My Lord, there's also an alternative in this regard. Alternative count to count 12, corruption, contravention of section 4 of Act 12 of 2004, that the accused are guilty of the crime of corruption in contravention of section 4(1)b, radio sections 1, 2, 4(2), 20, 24, 25 and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004, in that during the time and place mentioned in the main count, the accused directly or indirectly and wrongfully and corruptly gave or agreed or offered to give any gratification to a public officer, namely accused 11, whether for the benefit of that public officer or for the benefit of another person, namely payment of 600,000 on his behalf in order to act personally or by influencing another person so to act in a manner that amounts to the illegal, dishonest, unauthorized, incomplete or biased, or misuse or selling of information or material acquired in the course of the exercise, carrying out, or performance of any powers, duties, or functions arising out of a constitutional, statutory, contractual, or any other legal obligation that amounts to the abuse of a position of authority and or a breach of trust and or the violation of a legal duty or a set of rules designed to achieve an unjustified result and or that amounts to any other unauthorized or improper inducement to do or not to do anything.
Have you understood the alternative to count 12, Mr. Sadi?
Yes, I do.
And you plead not guilty.
Thank you, my Lord. We then move to count 40 on page 44, corruption. Contravention of section 3 of Act 12 of 2004, that the accused are guilty of the crime of corruption in contravention of section 3b Roman numeral 1 and or Roman numeral 2 and or Roman numeral 3 and or Roman numeral 4, read with sections 1, 2, 20, 24, 25 and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004. In that during the time and place mentioned in count 13, the accused directly or indirectly and wrongfully and corruptly gave or agreed to or offered to give to any other person any gratification, whether for the benefit of that other person or for the benefit of another person, namely the amount of 1 million rand paid from the account of accused 4, of whom accused 3 is the sole director on behalf of accused 11. In order to act and or omit to act personally and or by influencing another person to act in a manner that amounts to the illegal, dishonest, unauthorized, incomplete or biased, or misuse or selling of information or material acquired in the course of the exercise, carrying out or performance of any powers, duties, or functions arising out of a constitutional, statutory, contractual, or any other legal obligation that amounts to the abuse of a position of authority and or a breach of trust and or the violation of a legal duty or set of rules designed to achieve an unjustified result and or that it amounts to any other unauthorized or improper inducement to do or not to do anything. In that accused 3, 4, and 5 unlawfully and intentionally paid 1 million rand on behalf of accused 11 after accused 11 participated and or assisted in the appointment of accused 3, 4, and 5 as service provider for the Department of Human Settlements, of which accused 11 was a Director General.
You understand count 14 against you, Mr. Service? Yes, I do. And you plead not guilty of guilt.
Thank you, my Lord. There is also an alternative in this regard. Alternative count to count 14, corruption, contravention of Section 4 of Act 12 of 2004. That the accused are guilty of the crime of corruption in contravention of Section 4.1b, read with Sections 1, 2, 4.2, 20, 24, 25, and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004, in that during the time and place mentioned in the main count, the accused directly or indirectly and wrongfully and corruptly gave or agreed or offered to give any gratification to a public officer, namely accused 11, whether for the benefit of that public officer or for the benefit of another person, namely payment of 1 million rand on his behalf in order to act personally or by influencing another person so to act in a manner that amounts to the illegal, dishonest, unauthorized, incomplete, or biased, or misuse, or selling of information or material acquired in the course of the exercise, carrying out, or performance of any powers, duties, or functions arising out of a constitutional, statutory, contractual, or any other legal obligation that amounts to the abuse of a position of authority and or a breach of trust and or the violation of a legal duty or set of rules designed to achieve an unjustified result and or that amounts to any other unauthorized or improper inducement to do or not to do anything.
Understand the alternative to count 14, Mr. Sadi? Yes, I do. Thank you.
Just one moment, my Lord. My Lord, if we may then turn to page 63 again. This is in reference of the money laundering counts. This also refers to specifically Annexure B on page 92, referring to counts 29 to 37. My Lord, I'm not sure if that is required that I read the money laundering counts into record again. My apologies, my Lord, is also with regards to counts 21 to 28. Therefore, it's counts 21 to 28 as well as 29 to 37, referring to Annexure A and Annexure B of the schedule to the indictment. And also Annexure C, referring to counts 38 to 46, as well as Annexure D, counts 47 to 52, as well as Annexure E, counts 52 to 54. My Lord, just for guidance, that then starts, the annexures start on page 92, 93, 94 of the indictment. And if we then refer to page 95, Annexure G, this is count 63, as well as then Annexure H, my apologies, also on page 95, count 65 and 66, as well as count 73 on page 96 relating to Annexure J of the indictment. My Lord, furthermore, Annexure M on page 97, count 76, as well as in Annexure O on page 97 being count 78, 79 referring to Annexure P, and lastly, my Lord, count 80 referring to Annexure Q, also on page 98 of the indictment. My Lord, I'm not sure if it's prudent if I perhaps repeat with regards to the counts just to make it easier for the court as well.
You are going to repeat several things.
As the court pleases, my Lord.
Look, we have dealt now with count 14.
Indeed so, my Lord. As well as the alternative.
As well as the alternative. Now, which is the next count?
The next counts begin on counts 21, my Lord. That is page 63 of the indictment. If I may then read them in line of what is also the annexure to make it simpler. Count 21 and up until 28 hold correlation with annexure A of the indictment on page 92.
Counts 21 to 28.
Indeed so, my Lord. And that is with regards to annexure A of the indictment, and those all refer to money laundering.
My Lord, if I may,
relation, just a moment.
Sorry.
I want to make it easier for all of us. Mr. Sodi, the state is now going to deal with counts 21 to 28. Those are counts all dealing with money laundering. Can I assume that you are aware of the contents of those counts, or do you want the state to read them out?
No, I'm aware.
Thank you. And what do you plead counts 21 to 28?
Not guilty.
Thank you.
Thank you, my Lord. Then the next are with regards to count 29 to 37. Still money laundering. However, this is in relation to annexure B on page 92 of the indictment.
Counts 29
to 37, my Lord.
Do you have the same situation here, Mr. Saint, that you were aware of the contents of those counts, 29 to 37?
That's correct.
And you also plead not guilty to those counts. Thank you. There are more counts against the specific accused, isn't that so?
Quite a few more, my Lord.
I'm going to take the lunch break now, and the court will adjourn until 2:15, 15 minutes past
I think I like your select. Yeah, I want to be identified with these things. I can hear you guys. It should be on the but I'll check it again for you. I just need some water. You're going to have to, we'll have to Tortured, abused, died. Oh, the person.
She's saying she should be in the room.
Am I right? Worse. Yes, that is my name. Worse now. I tried. Yes. TL.
Basically, conditions, whatever it is, you know. Can you get the name of the case?
Not yet. No, hers, not his. Hers, not his. Yes. Not him, it's her. Yeah, it's number 6. He is here. My people say with shells and no worries. Yes. Also, I think that could be yours. I think that could be yours.
All cell phones on silent, please. All cell phones on silent, please. Yankee.
Yeah, speak to you.
I think some of the accused won't hear you, I think there's some are still outside.
Outside.
My client's not here.
Don't wait for them. Everybody knows it's quarter past. Seems we've got a discipline problem as well, my lord. Accused 2. And representative on it. And then Mr. Rambao needs to address you as well.
My lord, my client also isn't present. I don't know if there's a problem with the storm that I'm hearing, but I don't see him in court. Accused number 13 is not present. Several of the accused weren't present.
My lord, I apologize for not having brought this to the attention of the court at the beginning of the matter. Accused number 6 is a company represented by Michelle Mpambani, who is not present in court today. I have just called to find out what's happening. I'm told that she's actually at the hospital admitted. I hoped that she was going to be here because when I spoke to her yesterday, the intention was that she would actually come through, but I've learned that she's actually not going to be able to come to court today. I'm, however, your lordship, in possession of instructions to proceed with the plea, if that is
okay with the court, and for me to be able to do it accordingly for the progress of the matter.
Thank you, Mr.
Rambao.
Yes, thank you. We will deal with it when we come to
Thank you.
We are now still dealing with
Indeed, sir. Indeed, sir, my lord. The next set of counts were with regards to counts 38 to 46 and Annexure C attached to the indictment, also relating to money laundering charges. 46, my lord, Annexure C. That is on page 93.
Necessary for the state to put all those charges to you? No, it's not. Are you ready to plead on those charges? Yes, I'm ready. What do you plead?
Thank you, my lord. Still with the money laundering counts, we now turn to Annexure D on page 93, and this is in relation to counts 47 to 52.
So the state now wants to deal with counts 47 to count 52. Those are also counts dealing with alleged money laundering. You want the state to read out those counts to you? I will tell them to do so if you need it. No, it's not necessary. Not necessary. But do you plead to those counts? Not you.
Thank you, my lord. The next relate to Annexure E, and that is counts 52 to 54, page 94 of the indictment, still with money laundering.
But the previous counts that we dealt with were 47 to 52. Now you say the next bunch is 52 to something.
Indeed, sir, my lord.
So, are there two counts 52?
Indeed, so, my lord. With regards to the charges that we have already pleaded on, my lord, is going to cause quite some disarray should we move it on. I'm not sure if we can make it 52A.
Yes, I suggest. It seems a typing error by myself. Unfortunately, I apologize. I typed all this. Believe it or not. Can I suggest we make it 52A?
No.
Capital A.
No, my lord, that's wrong. There's no 51. If you look at the annexures, there's 252, there's no 51. So it's just a matter of correcting the 52 to 51.
Yeah, sorry. Thank you, Mr. Lawrence. Yes.
So the previous ones were 47 to 41.
Indeed, sir.
Correct.
Does that change your plea, Mr. Sabi? Still remains not guilty up to count 51. So now you are at counts 52 up to what?
54, my lord. I believe now with, thank you to my learned colleague having pointed that out, it then rectifies the numerical order.
52 to 54.
Indeed, sir, my lord.
necessary, Mr. Sodi, to read out those counts to you?
No, it's not.
Thank you. What do you plead to those counts?
Not guilty.
Thank you, my lord. We then turn to Annexure G, relating to count 63, and we are still with regards to money laundering.
There is also this count, number 63, that deals with money laundering. What the state to read it out to you?
Not necessarily.
How do you plead to that count?
Not guilty.
Thank you, my lord. We then turn to Annexure H, still on page 95 of the indictment, and that is in relation to counts 65 and 69, also money laundering.
65 and 69.
65 to 66. My apologies, Your Worship, on page 95 of the indictment, Annexure H.
Is your position still the same as you said it as it relates to counts 65 to 66? Or do you want it to be read out to you? You want it to be read out?
No, I said it's the same. Yes,
Are you also feeling not guilty to that counts?
Thank you, my lord. Then it is Annexure J on page 96 with reference to count 73, also still money laundering. As court pleases.
What is count?
73, my lord.
Assume that the position is the same as far as count 73 is concerned.
It's the same.
Thank you, Mr. Sodi, and you are pleading?
Not guilty.
Thank you.
Thank you, my lord. Then we move to count 76, attached to Annexure M, which is also still money laundering, also on page now 97 of the indictment.
Position still the same, Mr. Sodi?
Still the same.
I'm still pleading not guilty. Okay.
Thank you, my lord. Count 77, along read with Annexure N to the indictment, also still money laundering.
Sorry?
Still the same. It's not guilty.
Thank you.
Count 78, along with Annexure O to the indictment, starting on page 97, also money laundering.
Sorry?
Still the same. Not guilty.
Thank you.
Annexure P, along with count 79 on page 98, also money laundering.
Still the same. Not guilty.
In relation to the money laundering, my lord, count 80, Annexure Q, still money laundering.
record calculating what
Thank you, my lord. I believe we are listening to some storm, but I shall just raise my voice. If we now turn to page 65 of the indictment in relation to count 81. It is Let's go, please.
Wat vir my aandag gepas het, om het te sê ek vir my dit is nie Farfetch nie, te gee sy twee van my volgens my regering self voor jou van wel, ek het baie meer
Ja, net op daai.
net op die regering ek sien nie al lang die 5 jaar saam
Dis wat jy wil hê.
maar ek het vermoed net ek sien die bal daar is die persoon trots ek sal dan doen
1, 2, and 23 of the Asbestos Regulations 2001, promulgated in terms of the Occupational Health and Safety Act 85 of 1993, that the accused are guilty of contravention of Regulation 7, subsection 2, read with Regulations 1, 2, and 23 of the Asbestos Regulations 2001. In that during the period December 2014 and March 2015, and in the Free State Province, the accused unlawfully contravened Regulation 7, subsection 2 by failing to consult with the relevant health and safety representative or relevant health and safety committee before causing an asbestos assessment for the presence of asbestos to be done, and or did not thereafter inform the relevant representative or committee in writing of the arrangements made for the assessment, and or did not make available the results of the assessment to the relevant representative or committee for comment. Count 82, contravention of Regulation 5, subsection 1, read with Regulations 1, 2, and 23 of the Asbestos Regulations 2001, promulgated in terms of the Occupational Health and Safety Act 85 of 1993. That the accused are guilty of contravention of Regulation 7, subsection 2, read with Regulations 1, 2, and 23 of the Asbestos Regulations 2001. In that during the period December 2014 and March 2015, and in the Free State Province, the accused unlawfully contravened Regulation 5, subsection 1 by failing to consult with relevant health and safety committee, and or failed to ensure that their employees were adequately and comprehensively trained on both practical aspects and theoretical knowledge with regard to the stipulations in Regulation 5, subsection 1, paragraph A 2O.
You noted count 82?
Yes, I have.
Count 83, contravention of Regulation 3, read with Regulations 1, 2, and 23 of the Asbestos Regulations 2001, promulgated in terms of the Occupational Health and Safety Act 85 of 1993. That the accused are guilty of the contravention of Regulation 3, read with Regulations 1, 2, and 23 of the Asbestos Regulations 2001. In that during the period December 2014 and March 2015, and in the Free State Province, the accused unlawfully contravened Regulation 3 by failing to notify in writing the Provincial Director as defined in Regulation 1 of their General Administrative Regulations, published under Government Notice R 1449 of September 1996, prior to carrying out any asbestos work. Thank you, my Lord. We then turn to count 85 on page 68 of the indictment. Corruption, contravention of Section 3 of Act 12 of 2004, that the accused are guilty of the crime of corruption in contravention of Section 3b, Roman numeral 1, and all Roman numeral 2, and all Roman numeral 3, and all Roman numeral 4, read with Sections 1, 2, 20, 24, 25, and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004. In that during the time and place mentioned in count 84, the accused directly or indirectly and wrongfully and corruptly gave or agreed to or offered to give to any other person any gratification, whether for the benefit of that other person or for the benefit of another person, namely the amount of 7,143,000 rand paid from the account of accused 4, of whom accused 3 is a sole director, to the account of B2B Consultants, an entity associated with accused 18, and from which she received 4,522,271 rand and 70 cents, and Kayona Events, an entity associated with accused 18, an amount of 2,591,798 rand and 17 cents, in order to act and or omit to act personally and or by influencing another person to act in a manner that amounts to illegal, dishonest, unauthorized, incomplete, or biased, or misuse or selling of information or material acquired in the course of the exercise, carrying out, or performance of any powers, duties, or functions arising out of a constitutional, statutory, contractual, or any other legal obligation that amounts to the abuse of a position of authority and or a breach of trust and or the violation of a legal duty or set of rules designed to achieve an unjustified result and or that amounts to any other unauthorized or improper inducement to do or not to do anything. In that accused 3 and or 4 unlawfully and intentionally paid 7,143,000 for the benefit of accused 18 and or her sister-in-law after accused 18 participated and or assisted in the appointment of accused 3, 4 and 5 as service provider for the Department of Human Settlements in Gauteng and or Free State, of which accused 18 was the acting head of department in Gauteng.
You heard the 85 necessary. I have, and I think
Thank you, my Lord. There's an alternative to this count. Alternative count, count 85, corruption, contravention of Section 4 of Act 12 of 2004, that the accused are guilty of the crime of corruption in contravention of Section 4.1b, read with Sections 1, 2, 4.2, 20, 24, 25, and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004, and that during the time and place mentioned in the main count, the accused directly or indirectly and wrongfully and corruptly gave or agreed or offered to give any gratification to a public officer, namely accused 18, whether for the benefit of that public officer, namely 18, or for the benefit of another person, namely payment of 7,143,000 rand for the benefit of the accused and or her spouse or persons unknown to the state, in order to act personally or by influencing another person so to act in a manner that amounts to the illegal, dishonest, unauthorized, incomplete, or biased, or misuse or selling of information or material acquired in the course of the exercise, carrying out, or performance of any powers, duties, or functions arising out of a constitutional, statutory, contractual, or any other legal obligation that amounts to the abuse of a position of authority and or a breach of trust and or the violation of a legal duty or set of rules designed to achieve an unjustified result and or that amounts to any other unauthorized or improper inducement to do or not to do anything.
Have you heard that alternative account? Yes, I have. Not guilty. By the way, how do you want to say your name? Is it Saudi or is it Saudi?
Saudi.
Saudi, yeah, I thought so.
Thank you, my Lord. We now turn to count 87 on page 72 of the indictment. Corruption, contravention of Section 3 of Act 12 of 2004, that the accused are guilty of the crime of corruption in contravention of Section 3b, Roman numeral 1, and or Roman numeral 2, and or Roman numeral 3, and or Roman numeral 4, read with Sections 1, 2, 20, 24, 25, and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004. In that during the time and place mentioned in count 86, the accused directly or indirectly and wrongfully and corruptly gave or agreed to or offered to give to any other person any gratification, whether for the benefit of that other person or for the benefit of another person, namely the amount of 1 million rand paid to accused 18, in order to act and or omit to act personally and or by influencing another person to act in a manner that amounts to the illegal, dishonest, unauthorized, incomplete, or biased, or misuse or selling of information or material acquired in the course of the exercise, carrying out, or performance of any powers, duties, or functions arising out of a constitutional, statutory, contractual, or any other legal obligation that amounts to the abuse of a position of authority and or a breach of trust and or the violation of a legal duty or a set of rules, designed to achieve an unjustified result and or that amounts to any other unauthorized or improper inducement to do or not to do anything. In that accused 3, 4, and or Ignatius Mbani or accused 5 unlawfully and intentionally paid 1 million rand for the benefit of accused 18 and or persons unknown to the state after accused 18 participated and or assisted in the appointment of accused 3, 4, and 5, a service provider for the Department of Human Settlements in Gauteng and or the Free State, of which accused 18 was the acting head of department in Gauteng.
You understand count 87, Mr. Sodi?
Yes, I do.
And you read not guilty. Thank you.
Thank you, my Lord. There's also an alternative. Alternative count to count 87, corruption, contravention of Section 4 of Act 12 of 2004. That the accused are guilty of the crime of corruption in contravention of Section 4(1)(b), read with Sections 1, 2, 4(2), 20, 24, 25, and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004. In that during the time and place mentioned in the main count, the accused directly or indirectly and wrongfully and corruptly gave or agreed or offered to give any gratification to a public officer, namely accused 18, whether for the benefit of that public officer, namely accused 18, or for the benefit of another person, namely the payment of 1 million rand for the benefit of the accused and or persons unknown to the state, in order to act personally or by influencing another person to so act, in a manner that amounts to the illegal, dishonest, unauthorized, incomplete, or biased, or misuse or selling of information or material acquired in the course of the exercise, carrying out of, or performance of any powers, duties, or functions arising out of a constitutional, statutory, contractual, or any other legal obligation. That amounts to the abuse of a position of authority and or a breach of trust and or the violation of a legal duty or a set of rules designed to achieve an unjustified result and or that it amounts to any other unauthorized or improper inducement to do or not to do anything.
Do you understand the alternative charge, Mr. Sodi?
Yes, I do.
You plead not guilty. Thank you.
My Lord, we then move to count 89 on page 77 of the indictment. Corruption, contravention of Section 3 of Act 12 of 2004. That the accused are guilty of the crime of corruption in contravention of Section 3b, Roman numeral 1, and or Roman numeral 2, and or Roman numeral 3, and or Roman numeral 4, read with Sections 1, 2, 20, 24, 25, and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004. In that during the time and place mentioned in count 88, the accused directly or indirectly and wrongfully and corruptly gave or agreed or offered to give any other person any gratification, whether for the benefit of that other person or for the benefit of another person, namely the amount of 10 million rand, in order to act and or omit to act personally and or by influencing another person to act in a manner that amounts to the illegal, dishonest, unauthorized, incomplete, or biased, or misuse or selling of information or material acquired in the course of exercise, carrying out of, or performance of any powers, duties, or functions arising out of a constitutional, statutory, contractual, or any other legal obligation. That amounts to the abuse of a position of authority and or a breach of trust and or the violation of a legal duty or a set of rules, designed to achieve an unjustified result, and or that amounts to any other unauthorized or improper inducement to do or not to do anything. In that accused 3, 4, and or Ignatius Mbani, and or accused 5, unlawfully and intentionally paid 10 million rand as gratification to accused 13, and that accused 13 had knowledge of the irregular and or illegal nature of the agreement between accused 3, 4, and 5, and or Ignatius Mbani, and or accused 5, and the Department of Human Settlements, and or accused 1, and unlawfully and intentionally condoned the irregular and or illegal nature of the said agreement and illegally requested and or accepted the said amount from accused 3, 4 and or Ignatius Mpambani and or accused 5.
Do you understand count 89, Mr. Sodi? Yes, I do. And you plead not guilty. Thank you.
There is also an alternative to this, my lord. Alternative count to count 89, corruption, contravention of section 4 of Act 12 of 2004. That the accused are guilty of the crime of corruption in contravention of section 4(1)(b), read with sections 1, 2, 42, 20, 24, 25 and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004. And that during the time and place mentioned in the main count, the accused directly or indirectly and wrongfully and corruptly gave or agreed or offered to give any gratification to a public officer, namely accused 13, whether for the benefit of that public officer or for the benefit of another person, namely payment of 10 million rand, in order to act personally or by influencing another person so to act in a manner that amounts to the illegal, dishonest, unauthorized, incomplete or biased, or misuse or selling of information or material acquired in the course of the exercise, carrying out, or performance of any powers, duties, or functions arising out of a constitutional, statutory, contractual, or any other legal obligation that amounts to the abuse of a position of authority and or a breach of trust and or the violation of a legal duty or a set of rules designed to achieve an unjustified result and or that amounts to any other unauthorized or improper inducement to do or not to do anything.
You understand the alternative to count 89, Mr. Sodi? Yes, I do. Thank you.
My lord, we then move to count 91 on page 81. Corruption, contravention of section 3 of Act 12 of 2004. That the accused are guilty of the crime of corruption in contravention of section 3b, Roman numeral 1 and or Roman numeral 2 and or Roman numeral 3 and or Roman numeral 4. Read with sections 1, 2, 20, 24, 25 and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004. In that during the time and place mentioned in count 90, the accused directly or indirectly and wrongfully and corruptly gave or agreed to or offered to give any other person any gratification, whether for the benefit of that other person or for the benefit of another person, namely the amount of 10 million rand paid to accused 11, in order to act and or omit to act personally and or by influencing another person to act in a manner that amounts to the illegal, dishonest, unauthorized, incomplete or biased, or misuse or selling of information or material acquired in the course of the exercise, carrying out or performance of any powers, duties or functions arising out of a constitutional, statutory, contractual or any other legal obligation that amounts to the abuse of a position of authority and or a breach of trust and or the violation of a legal duty or a set of rules designed to achieve an unjustified result and or that amounts to any other unauthorized or improper inducement to do or not to do anything. In that accused 3, 4 and or Ignatius Mpambani unlawfully and intentionally paid 10 million rand to accused 11 who participated and or assisted in the appointment of accused 4 and 5 as service provider for the Department of Human Settlements, of which accused 11 was a Director General.
Stand count 91, Mr. Sodi. Yes, I do. Thank you.
Thank you, my lord. There is also an alternative to this particular count. Alternative count to count 91, corruption, contravention of section 4 of Act 12 of 2004. That the accused are guilty of the crime of corruption in contravention of section 4(1)(b), read with sections 1, 2, 42, 20, 24, 25 and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004. In that during the time and place mentioned in the main count, the accused directly or indirectly and wrongfully and corruptly gave or agreed or offered to give any gratification to a public officer, namely accused 11, whether for the benefit of that public officer or for the benefit of another person, namely payment of 10 million rand, in order to act personally or by influencing another person so to act in a manner that amounts to the illegal, dishonest, unauthorized, incomplete or biased, or misuse or selling of information or material acquired in the course of the exercise, carrying out or performance of any powers, duties or functions arising out of a constitutional, statutory, contractual or any other legal obligation that amounts to the abuse of a position of authority and or a breach of trust and or the violation of a legal duty or a set of rules, designed to achieve an unjustified result and or that amounts to any other unauthorized or improper inducement to do or not to do anything.
Have you heard the alternative to count 91, Mr. Sodi? Yes, I have.
Thank you, my Lord. We then turn to count 93 on page 85 of the indictment. Corruption, contravention of section 3 of Act 12 of 2004. That the accused are guilty of the crime of corruption in contravention of section 3b, Roman numeral 1 and or Roman numeral 2 and or Roman numeral 3 and or Roman numeral 4, read with sections 1, 2, 20, 24, 25 and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004, in that during the time and place mentioned in count 92, the accused directly or indirectly and wrongfully and corruptly gave or agreed to or offered to give to any other person any gratification, whether for the benefit of that other person or for the benefit of another person, namely the amount of 5 million rand, to act and or omit to act personally and or by influencing another person to act in a manner that amounts to the illegal, dishonest, unauthorized, incomplete or biased, or misuse or selling of information or material acquired in the course of the exercise, carrying out a performance of any powers, duties or functions arising out of a constitutional, statutory, contractual or any other legal obligation that amounts to the abuse of a position of authority and or a breach of trust and or the violation of a legal duty or a set of rules, designed to achieve an unjustified result and or that amounts to any other unauthorized or improper inducement to do or not to do anything. In that accused 3, 4 and or Ignatius Mpabani and or accused 5 and lawfully and intentionally paid 5 million rand to accused 1, in that accused 1 participated and or assisted in the appointment of accused 3, 4 and 5 as service provider for the Department of Human Settlements, of which accused 1 was the head of department.
Do you understand count 93, Mr. Sodi? Yes, I do. I'm plead not guilty. Thank you.
There is also an alternative to this count. Alternative count to count 93, corruption, contravention of section 4 of Act 12 of 2004. That the accused are guilty of the crime of corruption in contravention of section 4.1b, read with sections 1, 2, 4.2, 20, 24, 25 and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004. In that during the time and place mentioned in the main count, the accused directly or indirectly and wrongfully and corruptly gave or agreed or offered to give any gratification to a public officer, namely accused 1, whether for the benefit of that public officer, namely accused 1, or for the benefit of any other person, namely the payment of 5 million rand in order to act personally or by influencing another person to act in a manner that amounts to the illegal, dishonest, unauthorized, incomplete or biased, or misuse or selling of information or material acquired in the course of the exercise, carrying out or performance of any powers, duties or functions arising out of a constitutional, statutory, contractual or any other legal obligation that amounts to the abuse of position of authority and or a breach of trust and or the violation of a legal duty or a set of rules, designed to achieve an unjustified result and or that amounts to any other unauthorized or improper inducement to do or not to do anything.
Understand the alternative count 93, Mr. Sodi? Yes, I do.
Thank you, my Lord. We then move to count 95 on page 89. Corruption, contravention of section 3 of Act 12 of 2000, Act 12, my apologies, of 2004, that the accused are guilty of the crime of corruption in contravention of section 3b, Roman numeral 1, and or Roman numeral 2, and or Roman numeral 3, and or Roman numeral 4, read with sections 1, 2, 20, 24, 25, and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004. In that during the time and place mentioned in count 94, the accused directly or indirectly and wrongfully and corruptly gave or agreed to or offered to give to any other person any gratification, whether for the benefit of that other person or for the benefit of another person, namely the amount of 1 million rand, to act and or omit to act personally and or by influencing another person to act in a manner that amounts to the illegal, dishonest, unauthorized, incomplete, or biased, or misuse or selling of information or material acquired in the course of the exercise, carrying out, or performance of any powers, duties, or functions arising out of a constitutional, statutory, contractual, or any other legal obligation. That amounts to the abuse of a position of authority and or a breach of trust and or the violation of a legal duty or a set of rules, designed to achieve an unjustified result and or that amounts to any other unauthorized or improper inducement to do or not to do anything. In that accused 3, 4, and or Ignatius Mphambani and or accused 5 unlawfully and intentionally paid 1 million rand to accused 12, in that accused 12 actively or tacitly participated and or assisted in the appointment of accused 3, 4, and 5, and or allowed the irregular and or illegal appointment as service provider for the Department of Human Settlements, of which accused 12 was the MEC. There's also an alternative to this count, my Lord. Alternative count to count 95, corruption, contravention of section 4 of Act 12 of 2004, that the accused are guilty of the crime of corruption in contravention of section 4.1b, read with sections 1, 2, 4.2, 20, 24, 25, and 26 of the Prevention and Combating of Corrupt Activities Act 12 of 2004. In that during the time and place mentioned in the main count, the accused directly or indirectly and wrongfully and corruptly gave or agreed or offered to give any gratification to a public officer, namely accused 12, whether for the benefit of that public officer, namely accused 12, or for the benefit of another person, namely payment of 1 million rand, in order to act personally or by influencing another person so to act in a manner that amounts to the illegal, dishonest, unauthorized, incomplete, or biased, or misuse or selling of information or material acquired in the course of the exercise, carrying out, or performance of any powers, duties, or functions arising out of a constitutional, statutory, contractual, or any other legal obligation that amounts to the abuse of a position of authority and or a breach of trust and or the violation of a legal duty or a set of rules, designed to achieve an unjustified result and or that amounts to any other unauthorized or improper inducement to do or not to do anything.
Sorry, do you understand the alternative to count 95? Yes, I do.
My Lord, those are then all the charges levelled against accused number 3.
My Lord, I confirm my appearance on behalf of accused number 3. And I further confirm that his pleas of not guilty on all of the charges are in accordance with my instructions. Additionally, my Lord, with a view to saving time, I record that he faces those charges in his personal capacity. He faces, or he represents, accused number 4 on precisely the same charges, my Lord. And the plea in respect of accused number 4 will be precisely the same. And the plea explanation will be the same as well. If he can confirm that as required by the Act, my Lord, then I'd be indebted, we can save time.
accused number 4 is a company.
Yes, my lord. He's the representative of that company, and that company faces precisely the same charges. My learned friend will confirm that, and he acts in his representative capacity in respect of all of those charges, my lord.
I see. I thought according to the indictment, accused number 4, the company is represented by accused 2.
No, my lord.
That is what the indictment says.
It's an error then.
Indeed, so my lord, I see that is yet unfortunately another typing error. It is most certainly represented by accused number 3.
Are you pointing fingers again at
Not at all, my lord. It is merely what the facts are.
Yeah, my lord, I'm just wondering because the one I have, it indeed states as represented by accused number 3, but it should read accused 3.
So what you are saying is that, if I understand it correctly, that in relation to accused number 4, the company can make the same increase as far as the plea is concerned.
Yes, my lord. I'm recording formally, my lord, that accused number 3 represents accused number 4, and that he will be pleading precisely the same plea to the same charges as they face precisely the same charges, and those pleas will also be in accordance with my instructions. And then have a combined explanation on behalf of both of accused number 3 and 4. So in the interest of saving time and not duplicating, I believe accused number 3 will confirm that to be the position, and I can proceed to place the plea explanation on record.
That is now on behalf of 3 and 4.
As your lordship pleases.
Have you heard the conversation, Mr. Sodi, between your counsel and the court?
Yes, I have.
And do you confirm what has been said by your counsel?
Thank you, my lord. The lord, accused 3 and 4 deny the allegations against them and put the state to the proof of all the allegations against them. Over and above that, my lord.
Can I just interrupt you? And I'm so sorry about it.
No.
I just want to make a note here for
Yes, your lordship. Thank you, my lord.
Yes, thank you. You may proceed.
My lord, additionally, in terms of Section 108 of the Criminal Procedure Act, accused 3 and 4 raise the following issues to be tried by this Honourable Court. And it's as follows, my lord. Accused 3 and 4 launched an application, my lord, in terms of a directive of the Judge President of this division, Judge President Musi. The directive was on the 3rd of November 2021. They launched an application, my lord, on the 19th of November 2021, which was the time frames within which they were required to do so, in which they claimed the following relief. And I'll read it slowly to your lordship, and if necessary, my lord, we will make copies of this notice of motion, but it is a matter of record. My learned friends all have it, my lord. So firstly, my lord, declaring that the indictment, insofar as accused 3 and 4 are concerned, is premised on evidence obtained from the Judicial Commission of Inquiry into allegations of state capture, corruption and fraud in the public sector, including organs of state. It's referred to, my lord, as the State Capture Commission. Secondly, my lord,
Reading evidence obtained by the state capture commission,
inadmissible, my lord. But the way we phrased it was declaring that the indictment, because the indictment was reliant upon that evidence, so we said that that indictment is irregular. Secondly, my Lord. Declaring that the state's reliance on accused three's testimony and evidence from the State Capture Commission renders any trial against these applicants, that's accused 3 and 4, my Lord, unfair and in breach of their fundamental right to a fair trial as envisaged by Section 35, Sub 3 of the Constitution of the Republic of South Africa, Act 108 of 1996, as amended hereinafter referred to as the Constitution.
Those were the issues raised before
As your Lordship pleases, yes, my Lord. I will get to that judgment as well, my Lord. The apposite paragraphs in the judgment, my Lord, are 49 and 52, but I will be quoting them to your Lordship. Thirdly, my Lord, declaring that accused 3 and 4 ought to have been excused from prosecution in terms of Regulation 8.1 of the State Capture Regulations.
That will be speak of
3 and 4, my Lord. Yes, ma'am. And then fourthly and finally, my Lord, there was alternative relief sought, and that was that the evidence given on behalf of accused 3 and 4 at the State Capture Commission infringes their fair trial rights as provided for in terms of Section 35 of the Constitution, may not be relied upon in any trial against the accused 3 and 4. My Lord, these issues were the subject, as your Lordship has pointed out, of an application before this Honourable Court, where your Lordship's sister, Naidu, held on the 28th of March 2022, essentially, and I'll refer your Lordship to the paragraphs in the judgment, that these are issues that this Honourable Trial Court ought to decide in the trial. My Lord, the starting point is, in support of this, is paragraph 49 of the judgment, where she stated that she is, however, aware that the trial court may view this differently. That's the reference to Regulation 8.1 and 8.2, particularly 8.2. Depending on what evidence and arguments are placed before it, should this issue be raised at the trial, in her view, all the relief that accused 3 contends for ought to be raised at the criminal trial. That's what she said in paragraph 49, and then she further elaborated on that, my Lord, in paragraph 52 as follows. I appreciate that, my Lord. I beg your pardon, you're suggesting it to what time, my Lord?
You and the machine is got the same problem.
Yes, my Lord. And I'm sure people behind me are worse, my Lord.
Yes, I suggest that we adjourn to 9:50 tomorrow.
That's your Lordship, please. Thank you, my Lord. I would appreciate that. I do believe that we've made some progress and that it would be apposite to do so. Thank you, my Lord.
This court will now adjourn to 9:50 tomorrow morning here at the same venue.
Thank you,
my Lord. There's just one issue, unfortunately, and that is the absence of Michelle Nkambani on behalf of accused number 6. She was warned to be here. She is not here. The state requested a warrant for arrest to be for immediate effect, and so that we can see if we can have a hearing by tomorrow. I'm talking about the police, my investigating officer. Why my colleague didn't disclose it to the court right from the outset, I do not know. But the fact of the matter is, she is not here, she was warned, and that's a contravention. We can't just let it hang in the air. Unfortunately, my lord, we need that ruling on the day that the person is absent. The court can even hold the warrant of arrest in abeyance, but some order has to be made, unfortunately. The representative of accused number 6, Michelle Mpabane. And the mere mention of, by my colleague, that she's apparently in hospital will not suffice. Again, the question is, why didn't you say it in the morning when we started? What the state would also request is that my colleague disclose to the court which hospital, if he knows, or which address, so that this exercise can be finalized very quickly to avoid another delay, as it pleases.
My lord, I'm in the court's hands.
You are indeed. That is
That's surprise number 5.
I was going to say to yes, you can issue it with immediate effect tomorrow morning. So then they can go. It's going to take a while to get that changes the position. They're holding it over until it held over. When was it? Now, for today, it held over. In other words, having physically gotten it, tomorrow morning we can get it. I suppose it was. Kaya.